Yes, good
Okay.
evening to the aspirants of the JCJ 2022, and today that we are going to deal the old question paper of the both AP and State 2016, and we have the key also with it. Now you read that what I posted on the screen. That is the participants. Participants, could you read what I posted on the screen? Participants, could you read what I posted on the screen?
Okay, sir. I volunteer to read it.
Okay,
Good evening to
read.
the aspirants of JCJ 2022, Telangana State, host Kolikonda Sharad Babu and Professor Dr. Mohammed Saheb Hussain.
Yes, and without wasting the time, let us go to the point. Yes, Kolakanda, go the first question. Kolakanda, go to the first question.
Yes, sir.
Read the
Yes,
first
sir.
question.
The first question is, two persons are within the degree of prohibited relationships if they are related by A, full blood, option B, half or uterine blood, C, adoption, D, all the above.
D, all the above. All the above. D, all the above.
Yes, is the D, all the above is the right answer.
D, all
Second
the
question.
above is the answer.
Sir, all options are marked there, no, sir, in that
No,
question.
no, some of them are marked, some of them are not marked.
Even though they are marked, some wrong answers are also there.
Go to the second question.
Second question. Second question, A contracts to pay B 10,000 rupees if B's house is burnt. This is A, void contract, B, contingent contract, C, waiver, D, none of the above.
B, contingent contract.
Yes,
Void
B,
contract.
The right answer
Option
is
A,
contingent
void
contract.
Option B,
B,
contingent contract.
Option B is the right answer. We have already come across contingent contract. Third question, abetting the commission of suicide is dealt with under option A, section 306 IPC, option B, section 307 IPC, option C, section 308 IPC, option D, section 309 IPC.
Option A, section 3.
Option A, section 306 IPC. Next question 4. Section 75 of the Indian Evidence Act 1872 deals with option A, primary evidence, option B, secondary evidence, option C, public document, option D, private document.
Option D, private document.
C, public document.
Yes, option D is the right answer.
Option
Private
D,
document.
that is the fourth question. Option D is the right answer. Next.
Yes, sir. So remove the key, sir.
Yeah. Fifth question.
Admission is defined in the Indian Evidence Act 1872 in option A, section 15, option B, section 17, option C, section 18, option D, section 20.
Option B, section 17.
Option B, section 17 is the right answer. Sixth question, an executive magistrate is empowered to grant remand under section 167 of the CRPC for a maximum period of A, 15 days, B, 7 days, C, 30 days, D, 90 days.
B, 7 days. B, 7 days.
B, 7 days is the right answer. Option B is the right answer. Seventh question. A and B jointly sued C for 20,000 rupees. Whether C can set off for the debt due to him by A alone. Option A, yes. Option B, no. Option C, neither A nor B. Option D, none of the above.
Yes.
No is the answer. Option B, no is the answer.
See, the seventh B is the answer.
Yes, that is B. Option B is the right answer. Next question.
Just
Sir,
a
how
minute.
can, sir?
Sir, don't show the key, sir. You are showing the key.
No, I already shown the key because to ascertain it, whether what is read is right or wrong. Oh, just a minute. Yes, now next.
Okay, sir. Next question is eighth question. A makes an attempt to steal some jewels by breaking open a box, but finds no jewels inside the box after it is opened, which is the provision of law under which he may be held guilty. Option A, Section 511 IPC. Option B, Section 420 IPC. Option C, Section 379 IPC. Option D,
Option
none of
A,
the
511 IPC.
Yes, option A, Section 511 IPC is the right answer. Ninth question. The act of child what under dash years of age is not an offense. Option A 5, option B 7, option C 12,
14.
14, option D 18.
7
Option
years.
B, 7.
Option B is the right answer, 7 years. Next, 10th question. What will be the effect of mistake as to law in force on the agreement? Option A, non-voidable. Option B, voidable. Option C, void. Option D, not void.
Option A, not voidable.
Yes, option A, not voidable is the right answer. 11th question. In which of the following cases the Supreme Court held that marriage of all persons should be made compulsorily registrable? A. Seema versus Ashwini Kumar. B. Geeta Jagdish versus Jagdish. Option C. Durga Tripathi versus Arundhati Tripathi. Option D. Ramesh Chand versus Rajeshwari Bai.
Option A,
Option A, Seema versus Ashwin Kumar.
Option A. Seema versus Ashwini Kumar is the right answer. 12th question. A marriage under the Hindu Marriage Act must be solemnized in accordance with customary rites of dash. A. The bride. B. The bridegroom. C. Both the bride and the bridegroom. D. Either the bride or the bridegroom.
D.
Option D, either bride or
Option
bride.
D is the right answer. Either the bride or the bridegroom. 13th question. Robbery is dacoity when the minimum number of persons involved is option A 10, option B 5, option C 3, option D 2.
Option B, 5.
Option
Five.
B is the right answer 5. At least there must be minimum of 5 members to call it a dacoity. Easement is a right. A in rem, B in personam, C neither A nor B, D sometimes in rem and sometimes in personam.
Right in
Option A, in rem.
Yes, right in rem. Easement is a right in
Supplementary
rem.
question. What is meant by right in rem? I repeat. What is meant by right in rem?
Right against the word, sir.
Right against the whole world. Next.
15th question. The expression good faith in section 51 of the Transfer of Property Act 1882 is used in the light of A. The Sale of Goods Act, B. The General Clause Act 1997, C. The Registration Act, D. The Specific Relief Act.
General Classes Act.
B. The General Clause Act 1897 is the right answer. 16th question. Secondary evidence of a document under Indian Evidence Act means A. Copy of the document, B. Oral account of the contents of the document, C. Both A and B, D. Only A and not B.
Option C.
Option C is the right answer. Both A and C and B. 17th question. A co-defendant in a case A cannot be cross-examined by another co-defendant in any circumstances. B can be cross-examined by another co-defendant. C can be cross-examined by another co-defendant when their interests are adverse to each other. D none of these.
C.
Option C can be cross-examined by another co-defendant when their interests are adverse to each
Yes, option C can be cross-examined by another co-defendant when their interests are adverse to each other. That is the right answer. 18th question. The remedies available against an ex parte decrees: A. Appeal, B. Review, C. Applicable to set aside, D. All the three.
Option D, all the above.
All the three is the right answer. Option D is the right answer. 19th question. Rescission can be granted: A. Where restitution to the original position not possible. B. Where the contract stands ratified. C. In severable contracts. D. In all the above.
D in all the above.
Option D.
D. In all the above, rescission can be granted. 20th question. Where there is a conflict between marshalling and contribution, Section 82 of the Transfer of Property Act provides that A. Contribution prevails, B. Marshalling prevails, C. Subrogation prevails, D. None of the above.
Marshalling.
B, marshalling prevails.
B. Marshalling prevails is the right answer. 21st question. Scroll up. An agreement not supplied by consideration is called: A. Nodum pactum, B. Consensus addendum, C. Quid pro quo, D. Nociter a Socrates.
Option A, Nodum pactum.
Option A. Nodum pactum. Yes. 22nd. For his commission or remuneration, an agent has A. Option A. General lien, B. Particular lien, C. No lien at all, D. None of the above.
Option B, particularly.
Option B, particular lien, is the right answer.
Supplementary question. What is meant by lien?
It's a right. Right.
Just short.
Anyone?
I think right in a foreign thing.
No. As a lien means a right to detain a thing till you realize the service charges. That is one lien. But in the casual leave and medical leave, lien is different. Because when you work for the more than 5 years or 7 years, you will entitle for the some type of the sabbatical leave. Then we can say it's a lien.
Yeah.
A particular
Some
year,
people,
in that lean period you can do any work of your choice.
yes, some
Okay.
people leave the department and go somewhere
Yes.
on leave.
Yes.
Yes.
Even foreign
23rd question.
services.
Yes. 23rd, a time-barred debt can be claimed as A. Counterclaim, B. Fresh suit, C. Set off, D. None of this.
D, none of the above.
Yes. D. None of the above is the right answer. 24th question. The offense of conspiracy is complete as soon as the parties have agreed to do an illegal act. This is A. True, B. Partly true, C. False, D. None of this.
A true.
B, partly true.
A. True is the right answer. As soon as the parties have agreed to do an illegal act, that means that there is offense of conspiracy.
Generally, conspiracy goes with the another section. What is that section?
120A.
Repeat.
120A.
Wrong.
According
That is
to
article you are showing. Two or more persons joined together made such an attempt of the conspiracy, then another section also could be attracted. That is section 34 of
IPC.
common intention.
Common intention.
Okay, next.
25th question. How many types of punishments are prescribed in the IPC? A3, B4, C5, D6.
Option C, 5.
What are those? What are those punishments?
Deterrent. Rigorous imprisonment, forfeiture of property, fine.
Srividya, tell that 5 punishments.
Simple, rigorous, forfeiture. Fine.
Reformate, I think reformative punishment is also there.
Yeah.
Six, huh?
Distributive punishment, reformative punishment, deterrent punishment. One more is there.
Retributive.
Retributive punishment. Okay.
Retributive punishment. Okay. Next.
Yes. 26th question. The use of force by itself will not convert theft into robbery. This is A, true, B, partly true, C, false, D, none of these.
False. C, false.
A, true. The use of force by itself will not convert the theft into robbery. This is true.
Yes.
27th
What is
question.
burglary? Supplementary question.
The protection of
Supplementary question. What is burglary? If you don't know, you say pass on.
Pass sir.
House breaking with the force is called burglary. A dwelling house breaking should be there. Then only says a burglary. Next.
27th question. The protection officer under Domestic Violence Act works under the control and supervision of A, District Collector, B, Family Court, C, Magistrate, D, State Government.
Option C, magistrate.
Option C is the right answer, Magistrate. 28th question. The burden of proof as to ownership under the Indian Evidence Act lies on A, the owner, B, the tenant, C, the person who asserts it, D, in all these.
Option C, the person who accepts it.
Yes, option
Option
C is
C.
the right answer. The person who asserts it, who asserts the ownership, he has to prove it. 29th question. An appeal under the AP Land Encroachment Act shall be made ordinarily before the expiry of A, 30 days of the date of order, B, 60 days of the date of order, C, 90 days of the date of order, D, 120 days of the
Sumalata,
date of
mute.
B.
Option B,
60 days.
60 days of the
B,
date of the
60
order.
days.
Option B, 60 days of the date of order is the right answer. 30th question. Threat to commit suicide is A, coercion, B, undue influence, C, misrepresentation, D, intimidation.
Option A, coercion.
Coercion.
Option D,
Option A, coercion.
intimidation.
Sir, what is the
Yeah, I will show you. I will
about
show you. 30th, no?
Option A,
Yes,
Thirtieth
I
coercion.
is
have the answer,
the answer is yes. Where it is A.
Yes, yes. But does it not come under intimidation also, sir?
But generally they say coercion because if a person has kept a revolver in the zero range at the temple, then naturally we'll say it's a coercion, not undue influence. I repeat, a person has kept his revolver at the zero range at the temple. Do you know what is temple? Telugulo kanta antaru.
Yes.
Is it clear?
I am asking about intimidation, sir.
No, intimidation is different again because there is a threat is there, then you can say coercion. Intimidation, they use a different, indirectly. Indirectly they will make it out. That is called intimidation.
Okay, sir.
Next.
31st question. Assault can be caused by A, mere words, B, mere gestures, C, mere preparations, D, none of these.
Mere gestures.
B. Option B.
B, just.
Option D is the right answer, none of these. Sir, assault that should be
Okay,
followed,
let me check
mere
it.
words should be followed by mere gestures.
Yes, in
Words and
assault,
gestures should be there.
there is a apprehension should be there.
So gestures should be there along with words.
But generally we can say also gestures because a person comes with a clenched fist to give a punch to you. Yes, that's amount to assault. Yes, that amounts to assault, clearly speaking. But
Yes.
If you make such a punch behind you where you could not see it, that's not amount to assault. A reasonable apprehension should be caused to the person and జనకడం అంటారు చూడండి తెలుగులో.
Hmm.
In English, he will become a bit bewildered and he perplexed. Then we can say it's an assault. Okay, next.
32nd question. Where consent to an agreement is caused by coercion, fraud, or misrepresentation, the contract is A. valid, B. voidable at the option of the party whose consent was so caused, C. void ab initio, D. none of the above.
Option B,
Option
void.
B,
The option
voidable.
of
Yes.
party whose consent
Option B. voidable at the option of the party. whose
Supplementary
consent
question.
was so caused.
What is ab initio?
void at the beginning.
From the beginning, void.
Void at the beginning.
At the threshold. What is meant by threshold? Say pass on if you don't know.
Pass on.
ద్వారం దగ్గరే.
తెలుగులో కడప అంటాం చూడండి, తలుపు దగ్గర ఉంటుంది చూడండి.
గడప.
That is threshold means kadapa. In the beginning, the point. Okay, next.
Third question. 33rd question. The transfer of property pending suit is hit by the A. doctrine of lis pendens, B. doctrine of sub judice, C. doctrine of sub rosa, D. doctrine of res judicata.
Option A, doctrine of lis pendens.
Doctrine of lis pendens is the right
Okay, now
answer.
you explain the other doctrine of sub judice, doctrine of sub rosa, doctrine of res judicata. Yes?
Yes, sir. Explain.
Yeah, the res judicata means already decided.
Yes.
And even myself also doubtful regarding the sub judice is concerned. Let me.
Sub judice means as it is in the court,
Okay.
sir.
Okay. Sub judice means as it is. Is it?
As the court has to deliver it still. We should not talk anything when some suit is
Okay. Till the court will decide it, we are not supposed to talk on it. Is it?
Yes, sir.
Yeah, because it is somewhere disappeared. I don't know which key I pressed it. But anyway, I will go to the next JCJ. Yeah, it is here. Yeah, which is the question?
33 is over,
Yes.
I think.
Finish.
Okay, what is meant by doctrine of sub rosa? Even myself also did not
Awesome,
have
sir.
any knowledge. Doctrine of sub
There
rosa.
is no such kind of sub rosa in CPC.
Doctrine of sub rosa. Doctrine of sub rosa, New Latin, denotes as secrecy or confidentiality. So that is the sub rosa meaning. What is the meaning of sub rosa? Sub rosa means the legal term is under the rose denotes the secrecy and confidentiality. That is the word. Is it clear?
Yes, sir.
Okay, now let us go to our point. Yes, sub rosa, 30th. Yeah, next 34.
Which of the following is not a decree? A. Rejection of a client. B. Dismissal for default. C. Both A and B. D. None of the above.
Option B, dismissal for default.
Yes, option B. Dismissal for default is the right answer. It is not a decree. 35th question. Does a party to the suit have a right to summon the opposite party to give evidence? A. Yes. B. No. C. None of these. D. Dash.
Yes.
Yes, option A is the right answer. Yes is the right answer. Sometimes under D, no answer is also given, sir. Yes or no type is also given.
Okay.
36. Can the court examine witnesses before framing of issues? A.
Okay.
Yes. B. No. C. Never. D, none of these.
Yes.
Yes is the right answer. 37th question. In which of the following cases the Supreme Court held the delay in pronouncing the judgment amounts to denial of justice? A. Surendra Singh versus State of UP. B. Anil Rai versus State of Bihar. C. State of UP versus Chandrabhushan. D. None of these.
Option B, Anil Rai versus State
Yes,
of
option
Bihar.
B is the right answer. Anil Rai versus State of Bihar. 38th question. Can the court allow the party to summon a witness whose name is not included in the witness list? A. Yes. B. No. C. Never. D. None of these.
Yes. Option A, yes.
A. Yes is the right answer. 39th question. Normally, the plaintiff who succeeds would be entitled to mesne profits for the period of A. 1 year, B. 2 years, C. 3 years, D. 4 years.
C, 3
Option
years.
C, 3 years.
Option C, 3 years is the right answer. 40th question. Whether the suit for specific performance a third party to contract claiming independent title and possession is entitled to act as party to suit to adjudicate this case. A, yes, B, no, C, sometimes, D, A and
B, no.
Option
no.
B, no.
No.
option B, no is the right answer. Next, 41st question. After the preliminary decree, deceased Hindu is entitled to claim a share in the deceased husband's property after the remarriage. A, yes,
Which
B,
one you
no,
are
C,
reading?
depends.
41 you have to read.
One
Up-
you should read.
41.
After the Yes, sir. After the preliminary decree, whether the party is entitled to raise a fresh plea in the appeal filed against the final decree. A, yes, B, no, C, depends, D, none of these.
B, no. B, no.
Option
B,
B,
no
no.
is the right answer. 42nd question, whether the court has power to extend time granted for the performance of any act after the time granted by it had expired under section 148 CPC. A, yes, B, no, C, depends, D, none of these.
Option A, yes. Yeah.
Option A is the right answer. S is the right answer. 43rd question. Whether the widow of the deceased Hindu is entitled to claim a share in the deceased husband's property after the remarriage. A, yes, B, no, C, depends, D, none of these.
Yes,
Option
A
B,
option.
no.
Option A, yes. How is it possible, sir?
No. Let me check it. Let
option
me
B,
check it.
no.
43. 43, what is
Yes,
it? A. No,
the
it
option
cannot.
A
Once
is
the
right.
remarriage is there is no probability of again getting it. Because once she remarries, then she will not be entitled to. No, it is the inheritance. No, maintenance cannot be given. It's the inheritance.
Yes.
So it
Once
can
she
be right
is
answer.
married, she loses her right to the deceased
No,
husband's
only
property.
only maintenance can ceased.
Okay.
Next.
Now, 44th question. Can a client be amended after the suit has been disposed of by invoking section 152 and 153 CPC? A, yes, B, no, C, none of these, D dash.
B, no.
B, no is the right answer. 45th question. Is it possible for the court to pass more than one preliminary decrees? A, yes, B, no, C, depends, D, none of these.
Yes.
Option A, yes.
Option A, yes. 46. Limitation for filing an application under section 152 and 153 of CPC. A, 1 year, B, 2 years, C, 3 years, D, none of this.
D, none
Option
of
D,
this.
none of the above.
Option D, none of the above. Sir, what is the limitation for filing an application under section
No time
150?
limit.
No time limit.
Again, you have to see what is the
47th
linkage is there. Because it may say perhaps under 152 and 153, limitation period will not work over there.
Okay.
That is
47th question. Whether a party could be allowed to withdraw an admission made in the pleadings by way of amendment. A, yes, B, no, C, depends, D, none of the above.
B, no.
B, no is the right answer of 48th question. The remedy of the plaintiff when the plaintiff is rejected. A, to file a revision. B, to file a review. C, to file an appeal. D, none of the above.
Option A to file revision.
File an appeal.
To file an appeal, option C is the right answer.
Option B.
Supplementary question C. What is the difference between the revision and review?
Review clerical mistakes.
If a single bench has given the judgment, it can be, I think, reviewed by the bench, double bench or full bench. But anyway, check it, difference between the revision and review. But as for the appeal is concerned, directly going to the other court, appellate court, the Zenith court. Okay, 49th question, read.
49th question, whether the interim order passed in a suit that was dismissed for default will revive after the suit is restored. A, yes, B, no, C, depends, D, none of the above.
Option B, no.
Yes.
Option A is the right answer. Yes is the right answer. 50th question, the court can issue a warrant for the arrest of the defendant to issue his appearance under section dash of CPC. A 95, B 94, C 94A, D order 5, rule 1 of CPC.
Option C, 94A.
Option C is the right answer, 94A.
Okay, let me
51st
take the
question.
hold. Yes, now let me post it. 51 question. The suit for damages for breach of contract can be filed at the place A option where contract was executed, B where the plaintiff resides, C where the contract was to be performed, D both A and B.
Option D, both A and B.
Option A. Where contract was executed.
Sharad Babu, give the answer. Right answer.
Option D, A and B.
51st question. A
Give
is
the right answer for
sir.
51st question.
Where contract was executed is the right answer.
Where the contract was executed is the right answer for the 51 question.
Option A is the right answer.
Option A is the right answer. Okay, 52. In which of the following situation the court can grant exemption to the plaintiff from the necessity to substitute the legal representative of the any defendant who died during the pendency of the suit and proceed to pronounce the judgment? Option A, the defendant has remained ex parte. B, the defendant has failed to file written statement. C, option, the defendant having filed the written statement has failed to appear in a contest at the hearing, and D, all the above. Shoot.
Option B.
Option
All the above.
B. Option B.
All the above.
Sharad Babu.
Option D is the right answer, sir.
Okay,
All the
okay, okay. Now the 53rd question. Which of the following can exceed the pecuniary jurisdiction of the court? A, option set off. B, option counterclaim. C, option both A and B. D, option neither A nor B.
Option D.
Option D. A కాదు B కాదు.
Sharad Babu.
Option D is the right answer, sir. Neither
Yes.
A nor B.
Neither A nor B is the right answer for 53 question. Next, 54th question. Under section 10 of the CPC, the earliest suit is liable to be A, stayed, B option dismissed, C option rejected, D neither A nor B nor C.
D,
Option
neither
D.
A nor B nor C.
Confirm.
Option D is the right answer.
Subsidies కదా section 10
Subsequent suit stayed.
Okay. 55 question. A counterclaim can be set up. A, money suits only. B, option suits for recovery of damages only. C, all suits. D, none of the above.
Option C, all suits.
Money suits only.
money shoot.
C, all suits.
All suits is the right answer. C is the right answer.
Recovery damage. Yeah, CC.
C is the right answer for the 55th question. The 56th question. The guidelines regarding the arrest is cognizable offences punishable up to the 7 years were issued by the Supreme Court in dash Sania versus Ram Singh. A option, B option Kumar. A. Jaykumar versus State of Tamil Nadu. C is the Arnesh Kumar versus State of Bihar. D is the Shekhar versus State.
Option C, Arnesh Kumar versus State of Bihar.
Confirm?
Yes, option C is the right answer. Arnesh Kumar versus State of Bihar. Option C is the right answer.
Thank you. 57th question. Imprisonment in execution of a decree is dash. Is a rigorous imprisonment. B option simple imprisonment. C either A or B. D neither A nor B.
Option B, simple imprisonment.
Option B, simple imprisonment.
Supplementary question. In simple imprisonment, how many years punishment?
Actually, option D is the right answer, sir. Neither A nor B.
So neither A nor B is the right answer. Okay.
Because in case of civil imprisonment, it is neither rigorous nor simple, sir.
Okay. 58th question. Right of private defense is available. A option against all members of an unlawful assembly. B when a reasonable apprehension of the danger to the body arises from an attempt. C option threat to commit an offense. Though offense might not have been committed. D all of the above.
All the above.
Option D.
Confirm.
Option B is the right answer, sir. When a reasonable apprehension of the danger to the body arises from an attempt.
Yes, the B is the right answer for the 58th question. Shall I proceed?
I think we have already discussed this.
Yes, 59th
59.
question. Withdrawal of suit is governed by the Order 23 Rule 1 of CPC, B option Order 23 Rule 3 of the CPC, and C option A and B, and D option Order 23 Rule 3 capital A of the CPC.
59 option D.
Option B.
Order
sir.
13 rule 3.
33
Option
rule
A,
3.
Order 23
Option
Rule
A
1.
is the right
of
answer,
CPC.
sir. Order
Option-
23, Rule 1 of CPC.
Means A is the right option.
Yes, A is the right answer.
Okay, 60th question. Order passed under the Order 21 Rule 97 by the Executing Court is A option appealable, B option revisable, C option reviewable, and D option none of the above.
Option A,
None of
appealable.
the above.
Option A, appealable is the right
A,
answer.
appealable.
Okay,
Execution of
60th question, right answer is A, appealable. And 61 question. In the law of evidence, fact means and includes A, everything pursued by the senses, anything pursued by the senses. B, state of thing capable of being pursued by the senses. C, mental condition of a person of which a person is conscious. D, all of the above.
D,
D,
all of
all
the
of the above.
Yes, we all know it. D, all of the above.
Okay, 62 question. X is accused of an offense of rape. He can be subject to the following test for the investigation. A, polygraph test. B, narcoanalysis test. C, brain electrical activation profile, BEAP test. And D, none.
D, none of the
Option
above.
D, none.
Yes, sir. D, none is the right answer. Because all these tests are not included for a rape accused person.
Okay, if a woman is pregnant or not, what is the test could be used? Supplementary question.
Urine test.
If a woman is a pregnant or not, what test could be undertaken?
Urine test, sir.
Gravindex test. Gravindex. Gravindex. Gravindex test. Okay, 63 question.
In that,
Which of the following charges cannot be compounded with the permission of the court before which the prosecution is pending? A, Section 298 of the IPC. B, Section 426. C, Section 491 of the IPC. D, Section 338 of the IPC. Shoot.
Option C, 491 of IPC.
Confirm. Kulkonda.
option D is the right answer, sir.
Section 338 of the IPC.
Yes, sir.
Okay. 64th question. A. Indulge in a voluntary sexual intercourse with B. A married woman without the consent of her husband is guilty of adultery. The married woman B is liable to be tried with A as an A. abettor, B option adulteress, C option jointly co-accused, D none of the above.
D, none of the above.
Joint.
According to
490.
which is the case law?
Adultery.
490. Shiny Joseph.
Shiny Abraham
Joseph
versus
Joseph Shine versus Union of India.
Joseph
Joseph Shine versus Union of India. That is the case law. 65th question. A person accused of an offense before a criminal court can be called upon to give evidence on oath. A option, upon a request in writing from the public prosecutor. B, by an application made by the complainant. C, by a direction of the court. D, by the accused on his own request in writing.
Option D,
Option
by
D.
the accused on his
By-
own request.
Kolkanda, confirm.
Yes, sir, that is the right answer. By the accused on his own request in writing.
That means 65 question, right answer is D.
Yes.
Okay. Section 34 of the IPC create a substantial offense. B, introduce the principle of the vicarious liability for the offense committed by the co-accused. C, recognize that the co-participant in a crime must be made liable for his act in the commission of the crime by the co-accused. D, both B and C.
D,
Option
both
D,
B and
both
C.
B and C.
I
Yes,
told you
option
already
D
the
is
common
right
intention.
answer, sir. Yes, both B and C. D
Okay.
is the right answer.
Right. 67th question. The test identification parade pertains to the field of dash. Investigation, B, trial, C, option satisfaction of the investigating officer that is proceeding in the right direction, D, A and C.
Option A, investigation.
C.
Identification parade.
Option D is the right answer, sir. A and C.
A and C, investigation and satisfaction of the investigating officer. And satisfaction of the investigating officer, he is proceeding in the right direction. So A and C is the right answer for the 67th question. Now the 68th question. Which of the following criminal minor act was amended by the criminal law within parenthesis Amendment Act of 2013? Option A, the Immoral Traffic Act. Option B, the Juvenile Justice within parenthesis Care and Protection of Children's Act 2000. C, the Protection of Children from the Sexual Offences Act 2012. And D, Criminal Procedure Code.
Option C,
Option
protection
C.
of children from sexual offences act.
Yes, option C is the right answer, sir.
Okay, 69th question. Which of the following act is passed based on the Supreme Court guidelines? Option A, the criminal law within parenthesis Amendment Act of 2013. B option, the sexual harassment of the women at workplace at Act 2013. And C, Juvenile Justice Act 2000. And D option, none of the above.
Option B, sexual harassment of women at workplace.
Yes,
Confirm.
option B is the right answer, sir.
Okay, 70th
Vishaka
question.
guidelines.
70th question.
Option B is the right.
Yes, I understood. B is the right answer for the 69th question. Yes, 70th question. Which of the following new offences are introduced in the IPC by the criminal law within parenthesis Amendment 2013? A, striking. B option, voyeurism. C, acid attack. D, all of the above.
All of the above.
D, all of the above.
Okay, now you say what is stalking?
54 someone unlawfully.
Repeat.
Stopping, sir.
Following a girl without her
Following.
consent.
Okay, what is voyeurism?
Despite
Peeping through holes.
For any sexual activities of the others. Okay, C, acid attack, you know it. All of the above, you know it. So no explanation. 71 is, which of the following new section is inserted by the Criminal Law Amendment Act within parentheses 2013? A, section 354A of the IPC. B, section 326 capital A of the IPC. C, section 370 capital A of the IPC. D, all of the above.
D, all of the above.
D, all of the above is the right answer.
Okay, now
Yes, sir.
I don't know the details of the 354 card is the capital A 326, capital A 370. Please, you can also go through it, what it says about, because it is newly introduced, hence capital A is added to the Arabic numeral. Okay, 72 question. In which of the following cases is a preliminary inquiry permitted by the Supreme Court in the Lalit Kumari judgment? A. Option matrimonial dispute or family dispute. B. Commercial offences. C. Medical negligence cases. D. All the above.
D, all the above.
D, all of
Yes,
the above.
that is the right answer, sir.
Okay. 73rd question. In which of the following judgment has the Supreme Court ruled that the victim of a bigamous marriage is entitled to maintenance? A. Pinakin Mahipatra Rawal versus State of Gujarat. B. Badshah versus Urmila Badshah Godse. C option. Indra Sharma versus VKV Sharma. D. None of the above.
B.
Option A.
Option B is the right answer, sir. Badshah versus Urmila Badshah Godse.
Okay, the 73rd question, right answer is B. Okay, 74th question. The guidelines regarding the arrest of the judicial officer by the police were issued by the Supreme Court in dash Joginder Kumar versus State of UP, and B option MC Abraham versus State of Maharashtra. C is DK Basu versus State of West Bengal. D Delhi Judicial Service Association versus State of Gujarat.
Option D.
Option
Delhi
D,
Judicial
Delhi Judicial Services Association versus State of Gujarat.
Option D is the right answer, sir.
Okay, 74th question, right answer is D. 75th question, what is the maximum period of remand which can be ordered under the section 309 subsection 2 of the CRPC? A. 30 days, B option 60 days, C 90 days, D option none of the above.
Option C.
Shoot.
Option A, 30 days.
Babu, confirm.
Option D is the right answer, sir. None of the above.
None of the above is the right answer for the 75th question. Shall I proceed? Say yes.
Yes, sir.
76th question.
Yes.
The right of the private defense of the property against the robbery continues. A. Option, as long as the offer causes or attempts to cause to any person death or hurt or wrongful restraint. Option B. As long as the fear of instant death or of instant hurt or of instant professional restraint continues. C. Option A and option B. D. None of the above.
C.
Option A and option B.
C. C.
C. Option A and option B.
Option C.
Yes, option C is the right answer, sir. A and B.
Okay, next. 77th question. The common object of unlawful assembly can be gathered from dash. And A option, nature of assembly. B option, weapons used. C option, the behavior of the assembly on or before the occurrence. D, all of the above option.
The above.
Yes. Option D is the right answer, sir. All of
Very good. So 77th question, right answer is D. That is all of the above. Now 78th question, section 149 of the IPC is a option A, rule of evidence. Option B, specific offense. C, option definition clause. D, none of the above.
Option A. Rule of evidence.
Option A, rule of evidence.
Option B, specific offense.
Yes, sir. Option B is the right answer, sir.
Specific offense. Okay, 79th question. In the absence of the substantial evidence, option A, corroborative evidence can be used. B option, corroborative evidence has no worth. C, corroborative evidence may be or may not be used as per the discretion of the court. D, none of the above.
Option B. Corroborative evidence has no worth.
Yes, option B is the right answer, sir. Corroborative evidence has no worth in the absence of substantial evidence, substantive evidence.
Thank you. 80th question. Answer given by the accused under section 313 of the CRPC are A, option evidence. B, not an evidence. C, presumption. D, none of the above.
Option B. Not evidence.
D, none of the above.
Option
Option
B
B,
is the
not
right answer, sir.
evidence.
Not an evidence.
Okay. Now 81. The rule of res geste is applicable to A, civil cases only. B, criminal cases only. C, civil as well as criminal cases. D, none of the above.
C. Civil as well as criminal cases.
C is the right answer, sir. Civil as well as criminal cases, this res geste is applicable.
Very
Option
good.
C.
82. Conduct of an accused is dash. A option, not a relevant against him. And B option, relevant against co-accused. C option, not relevant against the co-accused. D option, dash.
relevant against the co-accused, option B.
That means B is the right answer.
Option C is the right answer, sir. Not relevant against the co-accused.
Not relevant against the co-accused is the right answer for the 82 question. 83. In which of the following cases the Supreme Court issued the guidelines to prevent acid attacks? Option A, Lakshmi versus Union of India. B, PUCL versus Union of India. C, Sakshi versus Union of India. D, none of the above.
Option A, Lakshmi versus Union of India.
Good.
That is the right answer, sir. Option A is the right answer.
Very good. 84th question. A bargain where one party agrees to assist another in recovering the property and to share in the proceeds of the action is called A, accord and satisfaction. B, wager and betting. C, champadi. C, D, consideration.
Option C.
Option A.
Champati.
Can you tell me what is meant
C
with
is the right
champati?
answer, sir. Champati is the right answer.
Which is the right answer for the 84th question?
C is the right answer.
What is meant by
Champati
champati?
already given in the 84.
Okay. 85th
Bargain
question.
where one party agrees.
Okay. Shall I proceed?
Yes, sir.
Okay, 85th question. In a lease of immobile property, what is transferred is A, right to enjoy the property. B, mere possession alone. C, option interest in the property. D, option mesne profits.
Option A, right to enjoy the property.
Right to enjoy the property.
Option A is the right answer, sir. Right to enjoy the property.
Okay, next 86th question. Caveat venditor means a seller beware, and B option buyer beware. C option let the parties beware. D option none of the above.
Option A, seller beware.
Then what do you say the buyer
Caveat
beware
emptor.
in the Latin terminology?
Caveat emptor.
Yes.
Caveat emptor.
Yes, I
Sir, after
yes.
this,
Okay, 87th question. Handing over the keys of the go down where the goods are stored is A, constructive delivery. B, symbolic delivery. C, actual delivery. D, none of the above.
B, symbolic delivery.
Option
option B is the right
B,
answer, sir.
symbolic
Symbolic
delivery.
delivery.
It is a symbolic delivery. 87th question. Right answer is 88th question. What is transferred in a mortgage is dash A, ownership. B, possession. C, interest. D, right.
C, interest.
Option C, interest.
It is only
Yes,
the
sir.
interest should be
C is the right-
transferred. Okay,
C is
9th
interest,
question.
sir.
Principle of quod timit means already one time it is dealt by Kolikonda Sharad Babu. Yes, A, some past injury to the rights or interest of a person. B option, some future probable injury to the right or interest of a person. C, some small injury not capable of the valuation. D, some small injury incapable of the valuation.
Is some small future probable injury to the rights or interest of a person. Option C.
Confirm?
Yes, sir. B is the right answer.
Right.
Future should be there.
Okay.
When you
90th
find
question.
future, you can shoot at it.
Okay. Shall I proceed?
Yes, sir.
Okay, 90th question. Under section 13 of the CPC, a foreign judgment can be challenged on the grounds of A, competency of the court pronouncing the judgment. B, being obtained by fraud. C, sustaining the claim founded on the breach of the law in force of in India. D, all the above.
Option A.
Option D, all the above.
Option D is the
Option
right
D.
answer, sir.
Option D.
Option D is the right answer because they will also see the what is the competence of the court which is giving the judgment for the foreign judgment, and being obtained by fraud. If any judgment be obtained by fraud also, they will check it either they don't follow it, and sustaining the claim for the founded in the breach of law in the force in India at the time which is the contrary to the any law which is there in India or to the constitution at the time. Foreign judgment cannot be used because it is a private international topic where enforcement and recognition of the foreign judgment. Okay, next. It is the next question is 91 question. The maxim res ipsa loquitur. Everybody knows it. A rule of law. B, rule of procedure. C, rule of evidence. D, rule of negligence.
C, rule of evidence.
What is the res ipsa
Rule of-
loquitur?
Yes, sir, that is the right answer. C is the right answer.
Yes, I admit it. I want to ask what is
Things
the recipe
speaks
selector?
itself. Things speaks itself.
Yes, I appreciate. And there is no necessity of proving again the negligence. Is it clear?
Yes.
Very good.
Yes, sir.
92 question. Judgment on admission can be given A. Under the order 12 rule 8 of the CPC. B option under the order 12 rule 6 of the CPC. C option under order 12 rule 4 of CPC. And the option D under the order 12 rule 2 of the CPC.
Option B, Order 12, Rule 6 of CPC.
Yes, sir. Option B is the right answer under Order 12, Rule 6 of CPC.
Okay, now 93rd question. Compensatory cost under the section 3535 capital A of CPC can be imposed to the extent of A. Rupees 3,000, B option 5,000 rupees, C option rupees 10,000, D option without any limit.
Option A, 3,000.
Option A is the right answer, sir. 3,000.
Good. 94th question. Sumalata, mute. Sumalata, mute. Okay. 94th question. An admission constitute A. Option A, substantive piece of evidence. B, corroborative piece of evidence. C option, conclusive proof. D option, none of the above.
Option A, substantive piece of evidence.
Yes, sir. Option A is the right answer. Substantive piece of
Good.
evidence.
95th question. A caricature is a document within the meaning of section 3 of the Evidence Act. Option A, true. Option B, not true. Option C, partly true. Option D, true in some conditions.
Option A, true.
Yes,
What?
option A is correct. Option A, true, sir. In the
What
list of documents, this caricature is also there.
What is meant by caricature?
Caricature is a drawing, amusing drawing, sir.
Calligraphy?
That is writing.
Muhammad Fida Ali Hussain, MF Hussain, is the world most calligrapher, painter on the cloth, and he is very fond of Madhuri Dixit.
Yes, just he sprinkles and makes a painting.
On the
Sprinkles
cloth.
paint and makes a
On the
Yes, sir.
cloth.
yes.
Okay, 96th question. Conditions when hearsay evidence may be admissible. Option A, when contemporaneous. Option B, when there is no interval enabling fabrication. C, both A and B. D, none of the above.
A and B. See both
Confirm.
A and B.
Option C is the right answer, sir. Both A and B.
Thank you. 97th question. After murder, the accused surrenders to the police with a severed head and gives confession. His conduct is relevant under section option A, 10th of the Evidence Act. Option B, 8 of the Evidence Act. Option C, 7 of the Evidence Act. Option D, 11th of the Evidence Act.
Option D, section 11 of
Option
evidence.
B.
Option B, section 8 of the Evidence Act.
Option B, section 8 of the Evidence Act is the right answer, sir.
So right answer for the 97th question is option B, that is the section 8 of the Evidence Act. Is it clear?
Surprisingly, some recent incidents happened like this, sir.
Okay,
The
okay.
offender came to the police station with severe heads of the murdered person.
Okay. When is such a thing, punishment is less.
I don't know, sir.
Because his honesty. Okay, let's see the 98th question. Test identification parade conducted during the investigation is relevant under section. Option A, 6 of the Evidence Act. Option B, 8 of the Evidence Act. C, both A and B. D, 9 of the Evidence Act.
Option D, 9 of the Evidence Act.
Yes, sir. Option D is the right answer. 9 of the Evidence Act. Section
Okay.
9 of the Evidence Act.
Okay, 99th question. Extrajudicial confession can be given before A, the investigating officer, B option, the judicial magistrate, C option, a police officer other than the investigating officer, D option, village administrative officer.
Option D, village administrative officer.
Yes, sir. That is the right answer. D is the right answer. Village Administrative Office.
If a confession is made, a statement is made to the police officer is admissible
No,
Judicial.
not admissible.
under which
No, sir.
section?
Not any.
25, Evidence Act.
What the section 25, what the evidence act says, if a person could not be heard more than 7 years, presumption is
That is dead. That is dead.
Presumption of death.
section.
Death.
108.
108.
Are you sure?
Yes, sir.
Then
Yes,
what is
yes.
115?
Estoppel.
Estoppel.
What it means by estoppel?
Prevent stopping from doing something.
When he has said something already, he should not speak against it again.
What is the latest, what is the remarkable or landmark case law in the estoppel?
Shut the mouth.
I say landmark case law in the estoppel. We discussed this case
Theodore
law.
versus Sears.
We discussed, even myself also could not remember, but we can say, of course, I know the Tanzanian case law estoppel.
Pickard versus Sears.
Okay, let us see the 100th question. An injunction cannot be granted when the plaintiff has no personal interest in the matter. Option A, true. Option B, false. Option C, partly true. Option D, true under certain circumstances.
Option Option A, true.
Option
Option
A
A,
is the right answer, sir.
Okay, now the supplementary question is, injunctions comes under the CPC or CRPC or Constitution or evidence?
CPC. Specific
None of the
reason
above.
clause.
No, we studied injunction, permanent injunction and perpetual injunction, and we studied the section also.
CPC.
That is in SR Act,
Specific
sir,
relief
but you
act.
did not see the SR Act. That's
Is
why
it?
we are saying none of the above.
Okay. Okay,
Sir,
now
in
this is the
99th question, there is logic also, sir.
okay. Please tell me.
The remaining A, B, C, they are all involved in the judicial proceedings, sir. The police officer involved, the judicial magistrate involved, investigating officer, but village administrative officer generally does not come. So, extrajudicial confession means that village administrative officer.
Like extrajudicial remedy means
Beyond law,
what are they?
Extra people other than the judiciary.
Oh, what is right hand definition means? Other than the left hand is right hand.
Sir, what is the answer for 100th question?
A, option A.
Okay, thank you.
What is the extrajudicial remedy in the law of tort?
Settlements.
Expulsion of the trespasser, recapture of the goods, distress damage feasant, abatement of nuisance. Are you following me?
Yes, sir, they are all extrajudicial
Remedies.
remedies.
Then what are the judicial remedies?
Damages and punishments.
Damages, injunction, specific restitution of the property. I repeat, damages, injunctions. Third one is specific restitution of property. These are the judicial remedies. And how many damages you know it? How many kinds of damages?
Monetary, extra monetary.
Say pass on, I will give the answer.
Yes, sir, pass on.
Pass on.
Nominal damages, contemptuous damages, exemplary damages, anticipatory damages. But the bad category is general damages, special damages. Do you have the thought in that our questions? Matamari with
No, sir.
Trividya.
Not in the entire paper. We don't have, I think, any questions on torts.
So
No, sir.
now,
Don't have in our syllabus.
okay, now
In
still,
syllabus not there.
Cisco WebEx is very much kind enough to us. And shall I stop? Can you see the ILU?
Caricature examples, one or two examples give us, sir. Any other examples?
Caricature in the sense,
Other than the map, other than the amusing map, any other examples are there for caricature?
oh, why do you worry? I can show you everything. Don't worry. Mother Google is there. Caricature images.
Actually, many
See.
cartoonists they
yes.
use this.
I have shown on the screen.
Easy, sir.
And here, who is she?
Yes, Jayalalitha.
Jayalalitha.
Who is he?
Jayalalitha, Amir Khan.
Amir
Amir
Khan.
Khan.
And even myself also don't know the other actors here. Who are there? What about him?
Shoban Babu.
Is it?
Yes, yes.
That is
Shoban
the
Babu.
caricatures. And carcass.
Vyangyamu.
Carcass means a dead body.
See,
Carcass.
dead body of animal is different. Dead body of human being is different.
Dead
Yes.
body of animal.
If it is a dead body of man,
Then that is a corpse.
CROPS. Okay. Lawyers use books like the All India Reports and Quinquennial Digest and a Criminal Major Act. Then what the medical doctor use?
Apron.
That is for dissection, for cutting and showing the organs of the body. They bring actually the dead body
They
and they
conduct
will
autopsy.
make the surgery and cut it and show the parts.
That is
What is the
autopsy.
dead body is called?
Anatomy class.
Anatomy.
There is a specific word is there.
This dissection, sir.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्च लागे, गाहे तव जय गाथा। जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे, जय हे, जय हे, जय 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 हे। अहरह तव आह्वान प्रचारित सुनि तव उदार